Hi, I'm Katrina Celine and I'm bringing you this video from the Broderick Celine Law Firm. And the purpose of this video is to help prepare you for taking your deposition. I'm going to go through what a deposition is, some general tips and guidelines on how to handle questions during a deposition, and basically try to familiarize you with the process and give you general guidelines that are applicable to any witness that's being deposed, whether on the plaintiff or on the defense side. It will be up to your individual attorney to go over areas of specific facts that you want to be sure you're comfortable answering questions about that pertain to your particular case. But this video is more of a general guideline to help you. And what I'm going to do to start this video is I'm going to let you know just generally what is a deposition. At a deposition, you're going to be asked questions under oath that you need to provide the answer for. You're going to be there with an attorney. Your attorney will come with you. And then the attorney asking you questions will also be there, and any other attorneys involved in the case if it's a multiple party case. The other parties don't have to be at your deposition, but they do have a right to be there, so be prepared, especially if it's might be emotionally upsetting to see those other parties, to prepare yourself for the possibility that they will be there at your deposition. The other person that will be at your deposition is the court reporter, and the court reporter will be typing up everything that you say, all the questions that the attorneys are asking you, and any objections that your attorney is making, so that at the end there's going to be a complete transcript of everything that was said during the course of your deposition. The other person, the last person that might be present at your deposition, is a videographer. Sometimes depositions are videotaped. You should know this beforehand because the party who's ordering you to appear for your deposition would, in written notice, alert you and your attorney that it will be by videotape, so you will know ahead of time. And that might be another additional person in the room, is somebody taking a video of everything that's going on. And at the beginning of your deposition, it's likely that the attorney for the first 5 minutes or so will let you know kind of the ground rules for the deposition and give you some guidelines. And I want to go over those guidelines now so that you're familiar with them, and also if the attorney does go over them with you, you will have heard them before and you'll be familiar with the process. And the first item is that you are being placed under oath when you're at a deposition. The court reporter will have you raise your right hand and you'll swear that you're going to tell the truth. And so you might be reminded of that at the beginning during the attorney's admonitions to you. The attorney might remind you that you're under oath, that your testimony at the deposition has the same force and effect as if you were giving testimony in a court at trial in front of a judge, and make sure that you understand that. The other thing that'll likely get brought up and that you should be aware of and familiar with is that you need to understand each question that's being asked of you. And so if you answer a question, you're going to be presumed to have understood that question. And that makes it very important that if you don't understand a question, to stop and ask that the question be rephrased. To just tell the attorney, I didn't quite understand that question the way you phrased it. Could you phrase it another way? Or I didn't quite understand what you meant by such and such a phrase. The other thing that's important, and that you'll likely be told at the beginning of your deposition, is it's important to make audible responses. And what I mean by that is spoken responses, so that you answer yes or no to a question as opposed to or shaking or nodding your head, because again, everything you're saying is being typed up by the court reporter, and the court reporter can only type up words. If the court reporter tries to type up a or it's not clear what response you intended to give on paper, even though it might be clear in the presence of the deposition itself. The deposition that's being taken, the court reporter's typing everything up. At the end, eventually it's going to be turned into a booklet that has all the answers and all the questions written up, you'll be sent a copy of that and asked to review it. And at that time, you can change any of your answers. You'll have the opportunity to do so. But the attorneys in the case will have an opportunity to comment on the fact that you changed your answer at trial. And so it's important at the deposition to really do your best to give full, complete, accurate answers right there at the deposition. Because if you later change your answer, the attorney can twist that around at trial to say, well, she said or he said one thing at the deposition and then changed his story later on to try to make it look like you're being inconsistent and not being truthful. The next thing I want to tell you about is that there can also be corrections during a deposition. So if you've answered a question and you realize that you forgot to mention something or you said something that's incorrect, you phrased it wrong, whatever the case may be, don't wait until your transcript is sent to you and you have the opportunity to change it later on. Change it as soon as you can, right then and there at the deposition, to correct your testimony as soon as you realize there's been an error. The other thing is you're entitled to breaks. You can take a break at any time for any reason. You should try to ask for a break after you've answered the question that's pending. But it is important for you to know that if you need to use the restroom, you're thirsty, you're hungry, you want to talk to your attorney, you just need a break from heavy questioning, you can ask for that and it will be given to you. The other thing that an attorney might ask you at the beginning of your deposition, so you don't get thrown off by this, is the attorney has the right to ask you if you're on any medication that might affect your ability to testify that day. And just be aware that that question might be asked at the beginning of your deposition. And generally, you can answer no as long as you're not on medication that's going to affect your ability to be honest and to answer and understand the questions. And so that's, in a nutshell, the general admonitions you might hear at the beginning of your deposition. They're the ground rules, and they familiarize yourself with the process. The next thing I'm going to go over with you are some general tips and guidelines, and there's also going to be some written materials if you just want to read them over in preparation for your deposition. Now I'm going to give you 21 tips for your deposition, and these are general tips. They could be applied for plaintiff or defendant, and if you can just go through these tips before your deposition, in addition to the specific things that your attorney advises you to go over, it'll make a big difference in the way your presentation and your testimony comes across. And it can avoid mistakes that could be crucial to your case. The first tip is to remember the name of the game, and that is whether you're the plaintiff or the defendant, when the other side is taking your deposition, they have a specific reason that they're doing that. Plaintiff's attorneys are taking a defendant's deposition to enhance the plaintiff's case, to find out more information that could help them win money from the defendant. On the reverse, when a defense attorney is taking the deposition of a plaintiff, their goal is to discredit the plaintiff, to create inconsistencies between what the plaintiff has said before and what they're saying at the deposition, and to in some way disprove the plaintiff's case. And so know that going in, especially with the inconsistencies, because attorneys can also try to get you to be inconsistent within the deposition. And so be careful about what you say and about making sure you understand the question so that you can consistently provide accurate information. The next tip, number 2, is never volunteer. And what I mean by that is never volunteer information that's not asked of you. Make the attorney on the other side work for your information, because the information that you volunteer may actually be hurtful to you, and you don't want to give things and information to the other side that they might not be entitled to otherwise. The third tip is make sure you understand each question. I often tell my clients, after you hear each question, pause just for a brief second and repeat the question to yourself in your mind. This will give you just enough time to make sure that you understand the question and you know what to answer. The end of the deposition, the court reporter is going to type up a transcript, a book of all the questions and answers. And in that book, what's important is going to be what your answer is. And it won't matter that you paused momentarily before you answered the question. The important part will be that you understood the question and answered it with the right information. The next tip, number 4, is along the same lines. Take time to think. Don't rush into answering a question. Especially this comes up, I find, when you get into the afternoon, you've been in the deposition for hours, you're tired, it's wearing on you. And sometimes attorneys will wait until the afternoon to really get to the hard questions. And at that point, you might be tempted to just answer quickly, get that thing over with. But it's at that time in particular vital that you absolutely take the time to pause, make sure you understand the question, and answer with all the information you can. Number 5, the next tip, is never guess. If you don't know the answer, tell the person asking you the question that you don't know. You can give your best estimate if you know approximately the right information. You can share the information that you do have. It's important to go over the crucial facts of your case so that you can remember important information at your deposition. But if you're asked a question and you really don't know the answer, you can just simply state, I don't know, or as I sit here right now, I don't recall. That brings me to number 6, which is remember that sometimes you can't remember. Don't testify based on an assumption rather than from a memory. And what I mean by that is if you know that 2 facts happen and you infer that one caused the other, but you didn't see it, then you can simply say and testify to your understanding of the facts. For example, if the question is, did you see the green car go through a red light? If you didn't see the green car go through the red light, don't answer yes. Even if you saw that the light was about to change and you saw that the green car hit another car in the intersection. So you assume the green car ran the red light. So what you can do is just testify as to all those facts you did see. But be sure that you're testifying based on what you actually witnessed and not what you're assuming happened, because that can get you in trouble. Number 7 is be patient. Depositions can be long and tedious. They can wear on you. The attorney on the other side can ask you questions that can be insulting. They can delve into private areas of your life that you're not used to having to talk about, much less have a court reporter typing your every word, or even a video camera videoing you testify about these private issues. But be patient. You will get through your deposition, and if you remember to be patient and to take your time, it'll help the process actually go more smoothly, and it will help your composure as a witness. And that leads me into the 8th tip, which is don't lose your temper. And this is really important, especially if the deposition is a videotape deposition, because that has the potential for being played at trial. Segments of it can be replayed at trial in certain circumstances. But also, even if it's not a videotape deposition, how you come across as a witness at your deposition can play into how much the other side values your case based on if they decide you're a good witness or not a good witness. Also, if you lose your temper and you get angry, your emotions might get in the way of you clearly stating the facts that you need to testify to in order to help prove your case. And number 9, along the same lines, is be polite but firm. You want to be respectful to opposing counsel. You want to be polite. You don't want to get angry and you don't want to be argumentative. But you do want to be firm. What I mean by that is, if you're being asked a question, especially if you're being asked it in a leading way or in a repetitive way, where you're being asked nearly the same question multiple times, your attorney most likely is objecting to that, saying objection, asked and answered, and doing what they can to interrupt the process and stop the opposing counsel from badgering you. But it's still going to get to you. And if you're being asked repetitive questions, don't get engaged in an argument. Don't let your temper flare up. Instead, just be polite but firm and firmly repeat your same testimony. Don't change it to suit the wording that opposing counsel is trying to work you into changing your answer to be. Stay consistent and firm. And number 10 is speak clearly. And this is important, particularly because of the deposition transcript. A lot of times, because of question and answer in person, everyone seems to understand what's being said and the questions and answers seem to flow. And especially in depositions that take on more of a conversational pace, where it feels like you're in a conversation with the opposing counsel, that can be dangerous because you might get into answering too quickly and your answer might not be clear once it gets into the typewritten questions and answers when you're reading it after the fact. So you want to listen to the question again, but you also want to answer in a way that's going to be helpful so that your attorney can take your testimony if needed for motions or for other reasons in the case, and can use that testimony and have a clear statement of what the facts are that's you've already given under oath. Number 11 is to always finish your answer. Don't let opposing counsel cut you off if you're in the middle of answering a question, or if you've answered one part of a question but you have more to say to make the answer complete. If an attorney interrupts you to start asking the next question, it's all right at that point to stop the attorney and say, I wasn't done answering your last question. The attorney will need to give you your time to finish the question they've already asked. And so if you feel like you're being interrupted, again, be polite but firm and just say, excuse me, I wasn't done answering that question, and get all your testimony out. The next thing, number 12, is correct your answer. And that is, if you've given an incorrect answer during your testimony, or if you've given a partial answer and you remember something and you're still in the deposition, it's better to correct it right then and there than to wait until after the fact. It's unfortunate that you gave the wrong information in the first instance, but do damage control as quickly as possible. Say, I'd like to correct something that I said previously, and correct your answer right then and there. You can also make use of a break with your attorney if you need to consult with your attorney on how to go about correcting the certain issue that you testified mistakenly about. Number 13 is to always read the documents that are placed in front of you at a deposition, and to read the document before you're asked questions about it. This is important because if you're just handed a document and it looks somewhat familiar to you, you might have the instinct to just immediately say, yes, I recognize this document, and not to read it in detail. But take the time to actually stop and read the document in detail. Because otherwise, you might get caught off guard. You might get asked a question that relates to something within the document. And it's better to be prepared and to answer having actually read what's been placed in front of you. Because if it's being introduced, the next most likely thing is that opposing counsel is going to ask you questions about what's stated in that document. So best to be prepared. As a side note, I once was at a deposition and an email was introduced to the witness. It was a defense witness, an HR person in an employment case, and she said she recognized the document. It was a heavy document case. There were lots of emails that had been introduced, and the attorney asked her, at this point in time when you wrote this email, did you know about the plaintiff's underlying sexual harassment complaint? And the witness said no. And then she was asked further, did you know that she was worried about retaliation? The witness said no, I could not. I didn't even know she had made any kind of discrimination or harassment complaint. The attorney said, are you sure about that? She said she was sure about that. The attorney then went to the last line of page 2 of that email, where that very witness wrote in that email comments about the plaintiff's sexual harassment complaint, comments about retaliation claims. She was in big trouble for not having read the document that was placed in front of her, just as an example of how things can go wrong if you don't read the document in front of you. And then the next tip, number 14, is listen to the objections that are being made. So in a deposition, generally the opposing counsel, the other person's attorney, is going to be asking all the questions or most of the questions. And your attorney is not allowed to speak. They're not allowed to answer the questions for you. They're not allowed to lean over and whisper things in your ear to help you in how to answer the question. The only thing the attorney is allowed to say are objections that they're raising. And while these objections serve a legal purpose and they'll be used at trial if deposition testimony is being entered into evidence, then objections made at the time will be used at trial. And so they are important for that reason. But they're important for a separate reason too. They're important because they are your attorney's only communication with you between when a question's being asked and when you answer. And so if an attorney objects, for example, objection, vague as to time, that's a signal to you, a hint. The other attorney might be trying to trip you up on what point in time they're referencing with that certain question. If the attorney objects, objection, misstates prior testimony, that's a big hint to you, a signal to you that you've talked about this subject before in your deposition, and it's important for you to be consistent, and that you need to think about what you've already said during the deposition and make sure you're not changing the way you're saying it, changing your story, and make sure you're not adopting the words of the opposing counsel who might be trying to twist what you're saying to fit what he's trying to prove, or she. And the other reason it's important to listen to the objections is to give your attorney a chance to make full and complete objections before you give your answer, because the court reporter is going to need to be typing up the question, the objection, and then your answer. So it makes the whole process smoother and easier if you just wait, make sure you allow your attorney the opportunity to make the objections, but also listen to them, listen for clues that can help you answer. Number 15 is don't fall for some opposing counsel's style. Some attorneys will try to kind of play games in a deposition to try to get the testimony that they want from you. And this can go on both sides of the spectrum. Sometimes it can be in terms of being overly friendly with you, befriending you, making it seem as much as possible like they're trying to help you, they're just having a conversation with you, they like you. And a lot of times that's for the purpose of getting you comfortable, breaking down your walls and boundaries, and trying to get you to agree with what they want you to say. And if they're the opposing counsel, they want you to say things that are damaging to your case. So that's something to be careful for. On the other side of the spectrum, some attorneys take a very abrasive style and ask a lot of leading questions, and sometimes can be a little bit of bullies. And that's something that's also difficult to deal with. Your attorney will help you by objecting. They can objection badgering the witness, objection argumentative. They can try to come in and help save you from some of that. Call for breaks. The attorney will do what they can. But you also need to realize that sometimes that's just the personality or the personality ploy of the attorney on the other side, and to just remain calm, listen to the question, wait for your attorney to object if objections are relevant and necessary, and then just answer the facts and stay as cool, as calm as you can. The next thing, number 16, is to give answers that could be understood by the general jury pool, and not to be overly technical with your answers. If you're overly technical with your answers, they're going to be hard for everyone to understand on both sides, but also you might be limiting yourself and overly limiting yourself to what you're responding to. So that's something to kind of be aware of and be careful with. Number 17 is check your baggage. What I mean by that is leave all your documents at home. Don't bring them with you to the deposition. Don't bring particularly documents that have not been called for production that the other side hasn't seen yet. During the course of your deposition, you might be asked about various documents, and if you happen to have them with you, you're giving the other side an opportunity to get extra information that they're not entitled to otherwise at your deposition. So just leave it at home. The next thing that I want to talk to you about, number 18, is don't assume falsely. And what I mean by that is you can decline to answer questions that are based on hypothetical assumptions. So, and your attorney can help you. Your attorney can object, objection, incomplete hypothetical, you might hear. But if you're asked a question that's a hypothetical question, and either if you don't understand it or it's based on assumptions that don't truly exist in your case, those you can ask to be rephrased, and you can have your attorney help out. Your attorney will likely object if those questions come up. And number 19 is be consistent. And this is one of the most important things that you can possibly do. On either side, plaintiff or defendant, it is crucial that you are consistent in your testimony. Especially if you're being asked repetitive questions. Again, your attorney's going to objection asked and answered, but you're still going to have to answer the question. Objections are for the record and to help you, but they don't, unless your attorney specifically tells you, I'm instructing you not to answer this question, you're still going to have to supply a response. And so, particularly in repeated questions, be very careful about being consistent. And I think the easiest way to do that is to again be very careful about listening to what the question is and to just giving the facts that answer that question. And if the attorney turns around and says, you've just for example, let's say you've just testified that it's a car accident case, and let's say you've just testified, you're the plaintiff, and you've just testified that you were heading home from a doctor's appointment, you had a physical, let's say you were heading home, you weren't in any rush to get home that day, and it was just getting to be sunset as you were leaving the doctor's office. And you've testified to that, and the attorney turns around and says, isn't it true that the line of sight wasn't clear because the sun was setting as you left the doctor's office that day? Well, you didn't testify to that. Yes, you testified the sun was setting as you left. You didn't testify anything about what the road looked like, if it was clear, if the sun was in your eyes or wasn't. And so you just need to, at that point, say, as I testified to you before, the sun was setting as I left the doctor's appointment, and then follow up with whatever the facts are about vision, about if the sun was in your eyes or if it wasn't. But the point isn't what the facts are. The point is, don't just agree to the rephrasing that the opposing counsel has given you. The next thing I want to say is be comfortable. And that's kind of a funny and ironic thing to say when I'm talking about depositions, because you're probably thinking, I'm going to be anything but comfortable. I'm going to have somebody typing up every word I say. I'm going to be asked questions potentially all day long by an attorney that's trying to disprove what I'm claiming. But you want to do everything you can to be as comfortable as you can in the situation. You have the right to call for a break whenever you wish. You shouldn't call for a break while a question's pending. You should wait until you answer that particular question and then call for a break. But call for breaks as you need them. If you're getting tired, if you're getting worn out, you need to use the restroom, you're thirsty, you're hungry, whatever the case may be, you're getting a little bit too stressed out by a particular line of questioning. For any reason, or if you want to talk to your attorney about something, for any reason you can call for a break, and you should do so when you need to. You shouldn't be made to feel uncomfortable just because of the situation. The last tip, number 21, is not to be afraid. And I know that that's hard to do and easy to say, but don't fear being the witness at the deposition. It's really practice for the testimony that you'll give if your case goes to trial. Be confident, remain in control. You have a story to tell. You want to get the truth out there. Be confident in yourself, and be confident that you know you're prepared, you know what happened to you, and you're going to come across as a strong, confident witness. And so there's nothing to be afraid of. As long as you tell the truth, you're consistent, you take your time in answering the questions, and you understand what's being asked of you and the answers you give, you're going to do great. So don't be afraid, be confident. Thank you. Something else I want to mention is why your appearance matters at your deposition. And kind of an extra tip is about what you should wear and how you should present yourself. And no matter what side you're on, plaintiff or defendant, I think it's important for you to dress conservatively. I would say in business type attire, and to make sure that you present yourself in a very professional kind of way, no matter what your case is about or who you are. I would say for women to make sure you're not looking too flashy, to not wear jewelry that's too big, to make sure that the line of your shirt isn't too low, that you don't have cleavage showing, particularly important if you're in a videotape deposition. But also, even if you're not in a videotape deposition, because it's the impression you're leaving on the other side's attorney. And it can be important how you come off as a witness. That can be one item that's taken into consideration when determining what the settlement value of your case is. How will a jury accept this witness? What will a jury think of her or him? And that has a lot to do with how you present yourself. So dress professionally, conservatively. Men, get a clean shave. Make sure you look put together, professional, well-groomed, I would say polished. And it just adds to the level of credibility and adds to what kind of witness you're going to make. Are you going to be likable? Stay true to yourself in how you dress, but within the confines of being professional and conservative. And now I have a guest witness with us. I'm going to ask him some deposition questions, and we'll go back and forth, and I'm going to stop when there are things that have been said and mistakes that have been made, so we can teach you what to do and, more importantly, what not to do at your deposition. And this is in the midst of a deposition for a construction defect case. Our witness is a property owner, and he's suing some companies, a general contractor and some subcontractors, for things that were damage done to the home. Mr. Broderick, have you ever seen that document before?
Yes.
Stop. I'm going to stop right there after the first question, because one thing that's really important and a mistake that's commonly made is documents are introduced during a deposition, either by your own attorney or by the attorney for the other side. And if a document's presented to you, don't just take a quick glance at it. Actually stop and take the time to read the document to make sure you actually have read it before and to know what's in it, so that for the questions that are coming up, you're prepared for how to answer them and you're not caught off guard by something that's located on maybe the second, third, fourth page down. Getting back to the deposition. So, Mr. Broderick, you own the property located on Acme Street?
Correct.
And can you list all the things that you contend are wrong with that property and damage you contend is caused by my client?
The lights don't work, and we don't know how to fix it.
Stop. Okay. Whenever you get a question presented to you at a deposition that's asking you to list all your contentions, or list all the things that you found wrong, or list all the problems you've had, all the parts of your body that are hurting if it's a personal injury case, first make sure that you pause after the question. That way you're going to give your attorney an opportunity to make an objection. There's a special objection called a Rifkin objection, where your attorney can step in and object to the fact that the other attorney is asking you for contentions from your lawsuit. But on top of that, you also want to stop and be sure that you're listing everything that you are contending, or at least you put some kind of qualification on your answer saying, as I sit here right now, I can recall X, Y, and Z, various things that were wrong with the property, but I'd have to go through my paperwork, or I'd have to review everything to make sure that it's everything that was wrong with the property.
Okay.
So back to my questioning. Did you complain that the problem with the flooring was the result of subcontractor X?
I don't recall.
Stop. Now, it's only natural that you're not going to remember everything, and there's going to be some questions that really you don't recall the answer to. But there are some specific questions that go to the heart of your case, that you need to remember in order to prove your case. You might be the only witness or person that your testimony is the evidence to prove that element of the case. Your attorney should go over what these key elements are in your case that are specific to the causes of action you've alleged. But for those key elements, it's crucial that you do remember them at your deposition, and that you don't answer "I don't recall," but that you actually state everything you can remember to support your case. Isn't it true that you always signed off on change orders that were presented to you?
Sure.
Stop. Okay, for this question, there's a lot of things all wrapped into one. The first thing is, repeated as in an earlier question, is there was no pausing before answering the question. So it was a quick jump in to say yes. And I was leading him to say yes. Isn't it true that? If a question starts with "isn't it true," your ears should perk up and you should be on guard, because it's a leading question. You want to be careful that you understand the question, you know what you're answering. So that's the next problem, is that the witness answered yes, but it hadn't been established that the witness knew even what a change order is, or who the change order was presented to him from. And so with a broad yes, a broad quick yes especially to a leading answer, is something to really watch out for and try to avoid in a deposition. Isn't it true that you always signed off on change orders that were presented to you?
What do you mean by signed off?
Stop. The reason I'm stopping here is that you've heard me say earlier that if you don't understand a question, stop and ask the person that's asking you the question to rephrase it. You want to be sure you understand each question. But you also want to be careful at the same time not to cross the line and become argumentative with the attorney that's asking you questions. It's not a conversation, and it's not an argument, and it's not the right thing to do to ask the attorney questions during your deposition or become argumentative. The best thing to do is to stay as calm and cool as you can, and to show the other side what a good witness you're going to be at trial. And you can do that by keeping calm, just sticking with the question, and making sure you understand it, but not crossing the line to be argumentative. Isn't it true that you always signed off on change orders that were presented to you?
What is a change order?
Okay, I'm going to stop here, but not because there's any mistake that's been made. I'm going to stop because this would be an appropriate question, an appropriate thing to ask. Our witness is asking for clarification on what one of the terms in the question means, and that's perfectly appropriate, and something that you should do is to ask for clarification if there's something you truly don't understand in a question.